Hello everyone, I'm Sanya Agrawal and I am back with another video on LegalEase, which is on foreign judgments. Now, why foreign judgments are relevant and how is it an important topic under CPC? For that, we will have to refer some of the provisions under CPC that are first of all Section 30, Section 40, and under execution section, Section 44A. So section 44, so these three sections, 13, 14 and 44A, these three provisions specifically talks about foreign judgments, wherein 13 and 14 talks about the conclusivity of foreign judgment and 44A talks about the execution of foreign judgment. So this will come on later because it basically gives us the process of how a foreign judgment can be executed in India. But first, as per section 13 and 14, we have to identify whether a foreign judgment can be considered as valid and conclusive in India, or you can file a same suit once it is decided in a foreign court again in India. So we already have discussed section 10, which bars res sub judice in foreign courts. Basically, it says if a foreign court is deciding a particular matter, the same matter on the same cause of action between the same parties is allowed in India, and section 10 bar will not be applicable. But what about section 11, which is on res judicata? There is no clear provision regarding it, so that is why we refer to 13 and 14. 13 talks about the conclusivity of the judgment, and through this we can find out how res judicata or whether res judicata is applicable. Now, why these provisions are given is in a reference to the private international law. We all the countries in around the world are sovereign countries, and we respect their sovereignty. And that is why to give respect to their sovereignty and to the decisions given by their court, we have these provisions wherein once a decision is given by a foreign court, we respect that decision and we consider it as a final decision and do not question it in Indian court if it fulfills all the requirements of our Indian laws. So we'll see those requirements under section 13, and we'll after understanding that, it will be clear to us that these type of decisions are considered as valid. So this is the language of section 13. It says a foreign judgment shall be conclusive. So foreign judgment को conclusive कब माना जाएगा? As to the matter thereby directly adjudicated upon between the same parties or parties under whom they claim, litigating under the same title. Except. So basically, this particular language, as we can see, is similar to that of res judicata under section 11. So a decision generally is barred by res judicata even if given by a foreign court, if the decision does not fall in these 6 categories. So we will see each category one by one. If a decision is not falling under it, then the decision will be valid and will be barred by res judicata in Indian courts as well. The first is where it has not been pronounced by a court of competent jurisdiction. That means even the foreign court that has pronounced the judgment should be competent in deciding that particular matter. Now, how will you decide the competency? So first, the competency is determined as per the jurisdiction of that particular country. Second, it is determined as per the principles of private international law. Also, it also allows the party to give consent to the jurisdiction of the court. So these are the certain criteria which allows a court to take the jurisdiction, and if according to that the court is competent, the decision will be valid and can be applicable as a bar on Indian courts. Second is it has not been given, if it has not been given on the merits of the case. We already know that if a decision is not given on the merits of a case, it is not considered as a valid judgment and it can be challenged, and it will never bar another decision or another case on the same cause of action because it was not heard and decided on the merits. So that is why if the merits of the case, that means the cause of action, the evidences on the basis to prove or disprove the cause of action has not been referred by the court, then the decision will not be valid and the same decision or same case can be brought in Indian courts as well. The third is where it appears on the face of the proceedings. On the face of the proceeding means that you will not get into the details and the merits of the case. If a foreign judgment has come before you, the court will only on the face of it check this point. On the face of the proceeding to be founded on an incorrect view of international law or refusal to recognize the law of India in cases which such law is applicable. That means if that foreign court has given a decision violating some principle of Indian law or any international law, then also that that decision will not be considered as a valid decision, and same case can be found in India. For example, if a particular dispute is decided according to the HMA, so basically two parties, Mr. A and Ms. B, got married in India and then settled in Canada. Now in Canada, there was some issue between them, and therefore they filed for divorce. Now, the Canada court referred to their law of their family law, and then according to their family law, they granted divorce to this particular couple, not referring to the grounds of HMA, but by referring to the grounds that are given in the local law of Canada, which is against the law applicable here. For example, irretrievable breakdown of marriage is not a ground under Indian law or Indian courts. Only in exceptional cases it is allowed. Now, let's say because the parties are not living together for 2 years and there is continuous, uh, they are continuously fighting with each other. So, considering this as a irretrievable breakdown of marriage, the divorce was granted by Canada court. We can say that this particular court did not follow the laws that are applicable on the party in this case, and therefore the decision will not be considered as valid. So that is how this particular point is applicable. So the international law, all the Indian law should be followed in the foreign court to consider it as a valid decision in India. The next is where the proceeding in which the judgment was obtained are opposed to the principle of natural justice. We already know that there are different three principles of natural justice in India. You are supposed to write those three principles in the comment section. So if any of that principle is not followed, the decision in itself will become void and will not be valid, and therefore cannot be considered as a conclusive decision in Indian court. For example, I'll tell you one of the requirement is right to be heard, which is audi alteram partem. So if one of the parties not heard and the decision was given, or a chance of hearing was not given, then the decision of that court will be invalid. Here, right to be heard means a chance of hearing should be given, wherein not just a notice is required to be given, but also the parties should know, the court should be aware that the legal remedies are available to the parties. It is accessible to the parties. They can appoint an advocate and can argue their case before the court. If they are satisfied with this, then it is considered that they have fulfilled the principle of natural justice. The next is where it has been obtained by fraud. Fraud means any kind of deception by one party to the court or to the opposite party. If there is any kind of deception and proved by the court, then that decision will become invalid. It can be proved even in an Indian court when you have come to declare that decision as a conclusive decision. And the next is where it sustains a claim founded on breach of any law in force in India. That means that particular claim itself is void under Indian law or is invalid under Indian law. For example, if there is a contract on gambling, which is invalid in Indian law but valid in some other countries. So if in case of gambling, there is a breach of contract between A and B and a suit is brought by A against B, and the decision is also given in that particular court where gambling is legal in a favor of A, that he is the decree holder who will be getting some amount from B as a judgment debtor. This decision is not valid in India because this will not be considered as a conclusive decision in India because it is violative or breach of the law in force in India. The law here is the contract law. So these are the points. If any particular point falls under any of these category, the decision will not be conclusive. Otherwise, a foreign court's decision will be conclusive. So there is a landmark case in relation to the foreign judgments. The name of the case is Y. Narasimha Rao versus Y. Venkata Lakshmi. I'll just write the name here so that you can note it down. This is one of the landmark case. There are other cases as well, but I'll be discussing this one. It's a very important case. Here, most of the points related to the conclusivity of the judgment under Section 13 were discussed. Herein, related to the competency of the court or jurisdiction, it was held that the parties, both the parties, that is the plaintiff and the defendant, they can give consent to the jurisdiction of a court. Then the court can acquire the jurisdiction. As per the local law, if they have the jurisdiction, that is also valid. And as per the international law principle also, they can have the jurisdiction. Moreover, a suit can be filed at a place where the defendant, or we can say the respondent, is living or residing or permanently living. So like in the Indian law, the defendant place of residence become a place of suing and the court will have the jurisdiction. Similarly, under international law and under this principle, or in this case it was held that if a respondent is permanently residing or staying somewhere, then that particular place, if governed in covered under the jurisdiction of one court, with that court will be considered as having the jurisdiction over that matter. Similarly, they have also said that whenever a fraud is proved, then the decision will become invalid, even if the fraud is related to the jurisdiction. So, for example, in this particular case, the husband, there was a divorce suit between husband and wife, and the husband proved it before the court fraudulently that his wife lives in a particular area, and that is why the court has the jurisdiction. While the wife did not live in that area, neither the court has the jurisdiction automatically, and therefore the court, this particular person acquired the decision of the foreign court on fraud, and that's why the decision was considered as invalid in India. Similarly, uh, the other requirements or the other essentials were also discussed in this case. I've already talked about each and every essential and the requirements under it. So if those essentials are not fulfilled, or if it is falling under any of those exceptions that are provided, or these A to 6, A to F, then in those cases the decision will not be considered as conclusive and it will not be barred to file the same suit in India, and res judicata will not be applicable. Moving to section 14. Section 14 is basically talks about presumption, that again in respect of private international law, we should presume. So the court shall presume, it is a mandate on the court, upon the production of any document purporting to be a certified copy of a foreign judgment, that such judgment was pronounced by a court of competent jurisdiction, unless the contrary appears on the record. But such presumption may be displaced by providing want of jurisdiction. That means the presumption will be in the towards the validity of the foreign judgment if a certified copy is provided by the party to the court. However, that particular presumption can be challenged and can be disproved as well, but the burden of proof will be on that particular party who is challenging the validity of the foreign judgment, and not the one who is providing the certificate copy of the judgment. So this is it related to the foreign judgments. I told you section 44A is also important. 44A is related to the execution. So basically it gives a procedure how a foreign judgment can be executed. So if the requirements of section 13 is fulfilled, that means if a judgment does not fall under any of the exception from A to F, then in those cases it is considered as a valid judgment, and that valid judgment can be executed even in India. So this is how it is done, and the whole process you can go through the provision. So I hope the things are clear related to the foreign judgments and its execution in India, and how it is considered as valid, and how res judicata is applicable on it. For more such videos and for any confusion, please subscribe and comment on my video. Thank you so much.